I bring you a first on Crime Bodge, a police officer who behaves almost impeccably. But given what comes after this visit, I wouldn't be showering them with praise just yet.
How are you doing, Sam? You alright?
Yeah, I'm fine. I just I don't quite fully understand why you're here. So, would you be able to give me a lowdown as to what you need to discuss?
Yeah, of course. Are you happy for me to speak in earshot of other people? Or would you prefer to speak in person? Because I can speak about it, but it's probably easier if I just speak to you in person.
It is in person, yes, and I prefer just through the ring. Is that okay?
Yeah, no, that's fine. So basically, Samuel, there's been an allegation of malicious communication made against you by somebody, and I'm the investigating officer. I'm going to need to interview you about it. So it's going to require you to come into Falmouth Police Station at some point to give your version of events.
I know you're just doing your job. I understand, but I would probably be happy if I don't.
Unfortunately, Sam, given the fact that we have evidence of this, you'll be required to come for a VA. You are legally required. If you choose not to accept that, then ultimately you would be arrestable, and you'd be coming to the police station through that way. So I can do it by way of being convenient, making it convenient for you, or we can obviously do it through a route which would be less convenient. And obviously that would probably be probably not your preferred option. So what I'm saying to you is, of course, but when you are prior to the interview, it's your legal right to have legal representation. So I can absolutely arrange for you to have a solicitor present. And also, obviously, if it's appropriate, obviously, then you can also have an appropriate adult present as well, if you so choose. That would be completely up to you. But ultimately, you do need to be interviewed with regards to
okay, but
don't think I'm sat here accusing you of anything.
I think you're not. I know you're not accusing me of anything. That the decision's still down to me, because what you're saying, an allegation, is really a summary offence. So you wouldn't really have any legality under Section 17 of the Pace Act to form any kind of arrest, if you're well aware. So
Samuel, just let me stop you. You can try and hit me with lots of legislation, mate. But the crux of the matter is that you will be required for an interview, and in that interview, that's your opportunity to give your version of your account. That's the point of the interview.
Yeah, okay.
It has to be a recorded interview. I can't just have an informal chat with you about it. It has to be recorded. So if we go for Saturday the 8th at 10 o'clock.
Go ahead.
I'll pop a letter through your. I'll write up a letter. I'll pop it through your letterbox here.
Yeah. Okay.
Yeah, and I'll arrange a solicitor for you for that. Is that okay?
Fair enough. Go ahead, do that.
No problem. Would you like an appropriate adult, or are you happy just with legal representation?
Tell you what, I'll fix all that stuff up. Just do what you need to do.
I'm just doing my job, mate. I've just got
you are, and I see you are.
I've just got to investigate this.
Yeah, you can by all means do so. So just put the appointment for the door, and I'll be fine.
Okay, all right, I'll do that. If you can just pop into your calendar Saturday the 8th at 10 now, so that it doesn't come as a surprise and you can plan for it, and I'll see you then. All right.
Okay.
All right, Sam. Nice one. All right, I look forward to seeing you then. You take care.
So, nothing to shout about here. This officer is entitled to knock at this man's door. He doesn't misstate his authority, make unlawful threats, or overstay his welcome. Admittedly, he does give an intentionally misleading account of his powers of arrest surrounding refusal to attend a voluntary interview. The officer has no power to force entry for a summary offence, as this man rightly states, and refusing to attend a voluntary interview is not an offence. The clue is in the words voluntary interview. Nor do the police have any additional powers to make an arrest because a person refused to attend one. In any event, the officer seems to take it on the chin and respectfully withdraws, perhaps to reflect upon his duty to uphold the law and remain within its limits during an investigation. not bloody lightly. Once back at the station and away from the prying eye of the ring doorbell, the officer resorts to form. When the interviewee fails to attend the interview he was under no obligation to attend in the first place, the officer loses his shit. He turns up with 3 other officers in tow who stake out the entry door until they get the opportunity to walk in behind some unwitting delivery driver. 2 officers hide behind the door, presumably with the intention of grabbing him as soon as he collects his parcel, while the other 2 wait downstairs and also hide because it's a slow day at the station and they're always willing to assist their colleagues with a misuse of force.
Can't answer the door right now, but if you'd like to leave a message, you can do it now.
Samuel, it's the police. You've got 2 options, mate. You either open the door to us or it gets put in. So you've got those options, mate. Yes, you did, Samuel. That's correct. I've been before. I've explained to you. You were invited to come to a VA interview with regards to offences that have been alleged against you, which you declined to come to the police station to talk with me.
That's my right.
I know you misunderstand. So just listen closely to what he's got to say.
I think, what do you need to do? Do you want to...
So I'll explain it to you, mate. So this time you're under arrest for suspicion of malicious communications, alright?
Right, okay.
You cannot say anything, but it may harm defence if you do not mention when questioned something you'll later rely on.
Right, okay.
Anything you do say may be given an evidence. Do you understand that?
Okay, well, I do have it on my
Yeah, that's
camera.
fine. And we have it all on ours. Ours are recorded.
Yeah, okay, so I will be wanting to sort of like obtain footage,
That's your right. That's fine.
The time is now 12:53.
Yeah, okay.
Alright. The reason for your arrest is for a prompt investigation, right, mate?
Right,
You just turn around and place your hand behind your back.
You want to do on the back.
Well, as long as you're cooperative with us,
Why not?
We have to make policy, I'm afraid. We have to put it on the back, all right? Just for your safety and ours.
So if we spot this one above, like that, okay?
Yeah,
Turn
okay.
that way, that's the easiest, and then that will be on like that,
Do
okay?
you have any idea who just...
Samuel, just to be clear, you're happy you want your Aunt Norma to be your appropriate adult?
She can be, could be, she could... It'd be better if she'd just be contacted.
Of course we'll contact her, that's fine.
Before I analyse all this, I want to make something clear. I have uploaded this video for one purpose, the same purpose I upload all videos, to highlight typical police abuses and compare them with the law. I am never fighting anyone's personal cause. I have no clue of the surrounding issues and whether or not this person has indeed sent a malicious communication. If he has, then like anyone else, he deserves to be punished, but within the law. My or anyone else's desire to see him face justice does not mean the police should be given carte blanche to suspend his civil rights, ignore due process and openly abuse the law. Because if they do it to him, there could come a day when they do it to you. If not to you, then someone that you care about. Malicious communications under Section 127 of the Communications Act is a summary offence, and it's important to stress that this is the offence the police are investigating here and the one that they ultimately lay charges for. And like it or not, Parliament reserves the right to kick in doors and drag people from their homes only for the most egregious criminal offences, all of which are set out under Section 17 of PACE. Nor can a warrant be issued by the court to make entry for a summary offence. The only way police can enter your home under these circumstances is if you invite them in. If you are a right-thinking, civilised human being, an invitation into a person's home looks like this. Not a 4-man rugby scrum of testosterone threatening to smash your door in with a battering ram. An empty threat in most cases, because if they do go ahead and opt for the battering ram, it will greatly aggravate their liability for wrongful entry if they smash your door down, even further than the liability they already owe for threatening to use the ram in the first place. The battering ram can only be used by officers trained to use it. Only select police vehicles carry one, usually the Armed Response Unit. Any officer attached to a call to make a false entry needs to know precisely why they are making that entry and to ensure they're acting within the law. They must also fill in the necessary use of false forms. This is usually enough of a disincentive to prevent the police from ordering up the battering ram. However, never underestimate the extent the police will go to enforce their egos above enforcing the law, and the willingness of their colleagues to entertain this. Even if you choose to open the door before they break it down, you are not consenting to their entry. You cannot consent to something that is made under threat of force. However, if you aren't recording your interaction, then it will always be your word against theirs, despite the fact that, as a matter of policy, officers must always record false entry on their body-worn videos. But police officers are very forgetful, and if they aren't forgetting to record it, they're forgetting that person's right to request it, and you may have a fight on your hands to get a copy of the video from them. When demanding entry to make an arrest, the police must specify, where practicable, the offence in question. This enables the occupant to determine whether the police are acting upon a lawful power of entry. This is especially important here as there are two potential malicious communications offences. It is the lesser offence they false entry for here, no doubt in the hope the occupant will confuse it for the greater offence. Refusal to properly clarify the offence in question is typical of these types of wrongful entries. In some cases, the police will turn up at a person's home under a false pretense of intending to arrest for an indictable offence. After forcing entry and on return to the station, they will then downgrade it to a summary offence. This is a corrupt and illicit practice that occurs thousands of times across the UK every year. Furthermore, it's also a criminal act. Under Section 6 of the Criminal Law Act 1977, anyone who uses or threatens violence for the purpose of securing entry into any premises for himself or for any other person commits an offence. Arguably, all the officers in this video have committed that offence and could potentially be prosecuted for it. But the courts and the CPS, operating under a discretion they do not possess, have placed officers outside of the law without any constitutional basis for doing so. Simply put, the law does not apply to the police. The second offence these officers commit is common assault under Section 39 of the Criminal Justice Act 1988. The arresting officer handcuffs a compliant suspect without any consideration as to whether that force is necessary. Yeah, but he isn't compliant because he didn't attend his voluntary interview and didn't open the door, so they have every right to assume him to be a threat through lack of cooperation. No. Nobody is obliged to follow an unlawful demand, and no use of force is permissible under such circumstances. Not that any of that matters, because if the officer does not consider whether or not his use of force is necessary before using it, that use of force automatically becomes unlawful. This officer outwardly admits he hasn't bothered to consider the use of force in the circumstances by admitting he's applying handcuffs due to false policy.
Why not?
We have to make policy, I'm afraid. We have to put it around the back, all right? Just for your safety and ours.
False policy does not trump an individual's right not to be subjected to unreasonable force. What is reasonable must be determined subjectively and objectively on a case-by-case basis, not as a blanket precaution. Health and safety reasons are no defence either. These are grown men in gangs with all the restraints, incapacitants and training they need to lead a compliant suspect all the way to the police car. If they need to manacle every person they arrest for their own peace of mind, irrespective of the humiliation and suffering it causes the detainee, they should not be police officers. They should take a job more conducive to their paranoid nature. So now we have 2 offences racked up against this man's 1. 3, if you count the fact that the officer's corrupt and improper exercise of their police powers is also a criminal offence under Section 26 of the Criminal Justice and Courts Act 2015, which is an indictable offence, I might add, where a police officer really would have grounds to kick a door in and make an arrest. So, there you have it. The police break 3 laws just to bring a person into questioning for 1. Is that right? And if you come to the conclusion it is not, then what exactly are we, all of us, going to do about it?